Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are going to talk about a plaintiff, that's someone who comes to the court seeking something, and a defendant, that's someone who resists what the plaintiff might be seeking. And the discussion we're going to have today is about a plaintiff who has come to the court and who has sought orders pursuant to Section 247A of the Corporations Act. And essentially, that's a section that allows the shareholder in a company, someone who owns some shares, to seek from the company itself books and records, documents from the company on certain bases. Now, the discussion that we'll be having today relates to the plaintiff who's a 1.15% shareholder in the defendant company. What the defendant company does, its sort of chief business, is that the defendant company owns a subsidiary company, wholly owns the subsidiary company, and the subsidiary company engages in NDIS services, the National Disability Insurance Scheme. And so it goes out, it provides assistance to people, and there are certain grants and certain payments it receives from the NDIA that administers the scheme on account of providing those services. Now this subsidiary is off engaging in this work and doing whatever it does. And there's a sort of dispute that arises between the subsidiary and the NDIA. And the nature of that dispute is that the NDIA says that there's been about an $800,000 sort of over grant, excessive grant paid to the subsidiary. There's a bit of back and forth. Eventually that number kind of comes down to $400,000. But on one view, this is kind of a domino that kind of falls, that sort of reveals that the governance of the subsidiary is not amazing. Administrators are appointed to the subsidiary. And what I might not have told you is that the relevant company here is listed on the ASX, listed on the Australian Stock Exchange. And so trading is halted once we find out that there are these complexities with the NDIA. In any case, administrators appointed to the subsidiary company. Those administrators find a lot of irregularities. They suggest there might have been some breaches of directors' duties going on, and it is recommended that the company be placed into liquidation. And indeed, that happens. And so liquidators are appointed, and the potential for the subsidiary to do further NDIS work is removed by the NDIA. And in short, the progress of the subsidiary company looks very poor indeed. Do you remember that this whole piece of litigation we're discussing today is between the plaintiff and the defendant? So it doesn't involve the subsidiary company directly. It involves the plaintiff, who are shareholders in the defendant, seeking documents from the defendant that might be thought loosely of saying what's going on between the company and this wholly owned subsidiary. What happened here? Are there some claims that the company might have in relation to what happened with a subsidiary company? Those claims might be in relation to those, or against the company's directors, the directors of the company? Or is there potentially what we might call a corporate oppression claim? Is there a claim that the shareholders might be able to bring in relation to potentially the defendant company being conducted in an unfairly prejudicial way? And so that's broadly the position that comes to court. The plaintiffs say, hey, look, there's this set of circumstances. It looks to us like there might be some potential claims that we might have as plaintiffs, some potential claims the company might have against its directors for allowing this subsidiary issue to arise. And we also are interested in the idea of can we get the company relisted? Can we get some commercial outcome here? We want to see some documents in relation to this. And so the court has to review the position in relation to, look, how does Section 247A work? How do these applications for documents look? And that is what the court does. And in short, the court has a discretion in relation to what kind of relief it's going to grant if it finds that there is some case to be investigated. And one of the really important elements here is that a Section 247A application isn't just a yes-no question of can a shareholder just get open books to every single thing relating to the company. It's not a question about, look, what's the general position of the company? It's a more specific, more surgical sort of application that has to be directed towards a very specific inquiry. And what the court does is grapple specifically with the issues raised in the plaintiff's application and grapple broadly with these 6 categories of documents, category 1, 2, 3, 4, 5, 6, that the plaintiff has said, we need all of these to have a look at whether we have a claim as plaintiffs against the company or against someone else, whether the company has a claim against its directors, whether there's the opportunity to think about relisting the company, whether something strange went on with the NDIS, whether something strange went on with the auditors, these kinds of things. And so the court, with great respect, entirely appropriately, works through each of the categories of documents and taking a look at the relevant claims that have been brought. And the court finds, well, some of the categories, yes, tick, you can have a look at those. Some of the categories, no, can't have a look at those. And some of the categories, maybe the plaintiff and defendant should have some engagement together to discuss what kind of documents might be available and what sort of categories might be able to be redrafted. And so documents that are ticked and are allowed to be presented are things like minutes of directors' meetings of the defendant, so that the plaintiffs are able to really grapple with what were these defendants talking about, what were they thinking about when the subsidiary was going down the plug hole, what was happening with the governance of that, how are we engaging in that, have there been any breaches of duties in relation to that. And the example of across documents that the plaintiffs were not granted access to correspondence that they were seeking between the defendant directors and, for example, the external auditors. The court said, well, chatting with the auditors doesn't really speak to a claim you might have against the directors or an oppression claim or anything like that. And so what we have today is a genuine success, but not an unlimited success, if we can frame it that way, for the plaintiff, who came to court seeking access to 6 categories of documents and ending up with a sort of edited version of that in order for it to more forensically and precisely consider the types of claims that it raised with the court. I hope that discussion assisted you, and I look forward to joining you again soon over another coffee and in respect of another case note. Cheers.